Yeah, good morning everyone and welcome to this first panel discussion of our competition day. And we are trying, or we will try to address the issue of how to ensure a level playing field between public and private owned businesses. I'm very happy to be here this morning because our three previous speakers in the morning session, they all brought up a good number of good reasons for why this is an interesting topic. And in particular, being in Latvia, we heard that Latvia, like many other, so to say, new European Union countries, have the problem there where we inherited a structure, we inherited a company structure with very large enterprises, which of course during Soviet times or communist times were state-owned, and many of them remain state-owned, and how to regulate it and how to address the issues that come with very strong players. So we have a good panel of speakers. It's very good in many dimensions. I think they are good geographically, they are academically, but they are also practitioners, ensuring that we will have a good discussion here. My idea about the discussion is that we give the speakers 10 to 15 minutes each for their introductory remarks, and they will cover, I know, a number of different aspects. Then we might have a few comments here. I might ask a question, and then I open up the floor for questions. And I do hope that you will have many, because having such a good audience should ensure that we will have good questions also from you. So who are then the speakers that we have here today? We have Professor Eleanor Fox from New York University, covering, I think in your research, covering more or less all of the world in terms of competition issues. It will be very, very interesting to have you. Equally interesting is Professor Frédéric, having a serious academic background, but now being in the OECD, so bringing in both the academic and policy perspective. Then we have Šarūnas, and this is a difficult name for a Swede, Keserauskas, Šarūnas K, coming from our neighboring Lithuania, being there the chairman of the Competition Council, and also having been more or less a colleague of mine, lecturing here in Riga on competition issues at the Riga Graduate School of Law. Then we have from the Netherlands Authority of Consumers and Markets, we have Anita Vegter, bringing in the Dutch perspective to this discussion. And I think welcome to the panel, and I would invite Eleanor to be the first speaker on stage. So please, Eleanor, and welcome to all of you.
Hello and good morning, and thank you very much, Skajita and the Competition Council for hosting this wonderful event for European Competition Day. I'm very happy to be here. I have done research on competition laws of the world. I did some research with Deborah Healy, and we looked at competition laws all over the world to try to understand what competition laws cover anti-competitive state acts of state bodies, and even measures. And after doing all that research, we narrowed in to European Union and Central and Eastern Europe, because those are the laws that are the most dominant on the books to cover anti-competitive state acts. So that's the background for a few things I will say today. First, I want to say a few more words about the coming of age of thinking about state restraints as integral with private restraints. And second, I'll say a few words about some examples where the authorities have enforced against state restraints. And third, but maybe we leave most of this to the panel discussion, why is this such a hard question to try to articulate the line that the state crosses when the state violates the antitrust law? So my word of background of the coming of age of this topic. For more than half a century, and this mostly is America, competition law was regarded as being about private restraints. And coming from mostly the United States, this was not a surprise because the United States was not a statist economy. And then several things happened along the way. Of course, maybe most important was the formation of then the European Community, 1957, in effect in 1958, which has very robust provisions that have antitrust offenses for state actors and also certain state measures that may be unduly anti-competitive. This was not noticed in the United States at all. And I want to move forward to some next really important marker, the fall of the Berlin Wall, because when the Berlin Wall fell at the end of 1989 and all of Russia and the Central and Eastern European countries moved from command and control to markets and to competition law, many of those countries realized that in order not to undermine the market that they were just starting to get started, they had to have laws that would be also catching anti-competitive acts of the state. About the same time, there was much work on an international level, and this includes work of Frédéric in the WTO, to show how private restraints were integral to public restraints, and private parties could induce the public enterprises to help them with their private restraints, and that therefore these elements should be seen as integral and together. For all of those years that they were seen as quite separate, and here I would speak, for example, from the United States, there was the thought that if it's the state officials must have power to do what they need to do to act in the public interest. There are lots of rules, regulations, and acts that have anti-competitive byproduct effects, but you cannot tread on the sacred territory of the state. And that is the concept that has gradually withered away with the understanding that the public restraints are often the most detrimental, the most undermining of the market. So, as I prepared for today, I looked at annual reports of both Latvia and Lithuania, and I found Skaidrita has a wonderful statement in the annual report of 2013, and she reflected some of this morning. We have faced the bitter truth, and now it's my paraphrase, that it is not only the private enterprises that are harming competition, but there are public bodies that are grabbing markets because they don't have to compete for them and causing harm to consumer interests. And then I was really very interested when I was looking at the Lithuanian annual report of 2011, where Šarūnas, who will elaborate more later, said at the very outset of this report, talking about what is competition law all about, he says, we safeguard competition by encouraging state institutions and undertakings to refrain from restricting competition. For the European Union, now maybe many of you know this very well, but I just want to highlight it because it really is a highlight of this somewhat new body of law that integrates public and private restraints. You have in the Treaty on the Functioning of the European Union, Article 106, which works together with your antitrust, your typical antitrust 101 and 102, so that public undertakings and those granted special rights are subject to the competition laws. And the exceptions are actually few. And public undertakings that have exclusive privileges have to justify if they're taking unduly anti-competitive acts, they have to justify that they must do so in order to carry out their public duties. So in terms of examples, my favorite one is Slovenska Pošta, where in Slovakia, the public entity had the right to postal services. There was an adjacent market. Private parties had the idea of doing some kind of hybrid mail where they would have electronic conveyance of certain invoices and then package them and send them out. They developed the market. They made a very good market. And then Slovenska Pošta said, oh, that's a nice market. I think I'll take it to myself. And it tried to do that. It tried unsuccessfully under the EU law. It even passed a regulation that would expand its monopoly power into this adjacent competitive market. And the European Union Court held, first the Commission, and then the European Court held that it could not do so under the TFEU Article 106 combined with 102. It was an abuse of dominance. There are many examples. I'll pass by my other ones right now, but only to say there are loads of examples in post offices and in ports and in electricity where you have a public body trying to grab a competitive market, which is and can be and very often is illegal under the EU law. So the second category is state measures. Again, the EU law is robust on prohibiting certain state measures that either facilitate anti-competitive activity like a cartel, or they simply confer or entrench dominance and facilitate abuse. And my favorite example there is the Italian matches case, where Italy had a law that all of the Italian match producers had to get together and establish quotas for Italy. And as you would expect, because they had the incentive, they gave all the quotas to almost all to themselves and reserved only a little tiny bit to the outsiders who wanted to get in, the Swedes and the Germans. And the antitrust authority brought proceedings. And this case went up to the European Court of Justice, and the European Court of Justice said that both Italy and the producers, the private producers, ran afoul of the law, and that Italy had to disapply its law. The third category, as I said, is state officials may be and often are complicit in facilitating cartels, especially procurement cartels. And I know that procurement offenses are some of the worst in this country and your neighboring countries. And Skajita, you mentioned before that procurement is 11% of the GDP in your country. In a number of countries, it's even larger. In some countries, it can be up to 30% of procurement, depending often on whether they're state-owned enterprises that are big buyers. There's huge fraud combined with and evidencing itself as bid rigging in procurement. And I know that Šarūnas is going to talk about Lithuania and an example that's in your annual report that I was very interested in on Lithuania. I want to go down to the part in my slide which quotes David Lewis, who was the chair of the tribunal in South Africa, competition in South Africa, and left that to go into, to have an anti-corruption group, that because according to him, the anti-corruption combined with anti-competition is really one of the biggest problems. So this is what David Lewis said when he was talking about cement, in a cement cartel in South Africa. It is hardly credible that a cartel involving such elaborate and complex rules could have remained undetected for 35 years without the cooperation of key individuals on the purchasing site. So this does resonate. I believe it is correct, and I believe that for many of these procurement bid rigging cartels, there is a government official who is a rogue official. And so I think that one of the tasks to think about is how to discipline the rogue official. And it might be possibly under some countries' competition laws. Some competition laws cannot reach it. I think some can. I think maybe some amendments to competition law can reach it because this person's a rogue government official not operating in the market himself. In any event, it's an item to be looked at and to follow as to how to discipline those rogue officials. We come back to a question I raised at the beginning. How easy is it and how hard is it, even in the articulation of what is the offense? How easy is it to have an offense by public bodies and state officials? How can you draw the line? I think it can be drawn. European Union has shown us that it can be drawn. And I think that going back to the basics of EU law is a very good place to start. And the Slovenska Posta case is a very good case to look at in terms of what is permissible and impermissible state action. Of course, there are problems of administrability, there are problems of enforcement, there are problems of whether you can get good remedies. But once you've articulated exactly what the offense is, the remedies can follow. They might need legislative action, but they can. So, concluding, state restraints are some of the worst restraints. Some of them are inadvertent in the sense that maybe the decision makers don't really realize how anti-competitive their laws are and don't realize that there's another way of achieving the same result even better. Some are not. Some are consciously helping out the cronies. The first category is going to be easier for any agency to get at. The second category is just going to involve discretion. The Baltic states are acutely aware of all of these problems. One recommendation I have is the issue that you have been dealing with in Central and Eastern Europe on state restraints is a very important issue that may not be fully appreciated to a lot of the rest of the world. I think the issue should be raised to a world level. I think there should be discussion as to what are good laws against state restraints. I think this can be done, for example, in the ICN. And I think that the EU should take a lot of credit. And so here is my last slide, a photo I took yesterday, and old Riga. I am very happy to be in Riga. You deserve a lot of credit, both Latvia and the European Union, and I celebrate with you this great competition day. Thank you.
And then we give the floor to Frédéric Cheny. Please, Frédéric.
Well, thank you very much, and I want first to thank the Latvian Competition Authority for having invited me here today. I'm very happy to be here in Riga. I'm going to focus on state-owned enterprises and the kind of problems that they raise and different angles under which one can try to focus the action against disruptive state-owned enterprises. I'm going to base myself partly on some of the work which has been done at OECD, and I want to mention the fact that the OECD has approached the issue of state-owned enterprises from three different angles. First angle is from the corporate governance angle, and in 2005, the OECD Corporate Governance Committee has produced guidelines on state-owned enterprises. So that's a set of rules, and I will mention some of the rules which I think are important for us. That's a set of rules which should apply to state-owned enterprises, I would say irrespective of the competition issues. Second, the Competition Committee has held in 2009 a roundtable and come up with some best practices seen from the point of view of competition law enforcement, best practices against state-owned enterprises. And I'm talking about what's going to happen in June and possibly over several sessions of the OECD. We are also taking the angle of competitive neutrality, which is a wider angle. I think that we will hear about what's happening in Denmark, in the Netherlands, about this later on. But competitive neutrality encompasses some of the rules that should apply to state-owned enterprises, as well as some of the rules that should apply to states, as Eleanor has mentioned. So I'm going to talk about the complementarity and the challenges of those different approaches. But the first question, of course, is the word state-owned enterprise a relevant word, the word that we want to use? Is the holding of shares by government really the issue? Or should we be more thinking about influence of states on firms? Because the influence of state on firms may happen through different ways. One of them is as a shareholder, but another as framing some of the rules that apply to the firm. So there is a first discussion about whether state-owned enterprises is too restricted a definition. Really what we're worried about are firms under the influence of states. Why is it important? I'm going to gloss over this because you're all aware of it. I mean, Latvia is a perfect example. Nearly 20% of GDP, 145 or 150 state-owned enterprises. A large part of the economy, not so much in manufacturing, but in finance, in telecom, in electricity, and clearly in transportation, of course, railways. But analytically, what are the issues that we're trying to get at? Not so much the fact that the government owns shares, but the fact that the state influence has some repercussions on the behavior of firms. First, there is the issue of the structure of SOEs. They may have both an activity in a monopolized field as well as an activity in fields that are open to competition, and there may be some cross-subsidies there which may be destructive of competition. So that's the first issue. A second issue which I think is quite important is that SOEs may not have a profit motive. And there are several possible reasons for this. The first one is that they are usually protected from takeovers and also protected from bankruptcy, so they don't have the discipline that pushes private firms to maximize profit. But also the fact that in many cases, there's a complex governance of SOEs. The accountability of their performance is kind of lost because there are many bodies that intervene, which allows them to pursue other motives than profit motives. A third dimension is that many SOEs, I wouldn't say all of them, but many SOEs maximize something else besides profit, such as growth or employment. So they don't follow the kind of rules that private firms follow. They don't have the same objective. They try to minimize costs through size and or to just keep employment high. So the question, one of the questions which I will deal with is, how does one apply the competition rules to firms that don't have profit maximization as an objective? The fourth or the third issue is that they may have a status which is favorable or sometimes unfavorable. They may have facilities in financing, for example, because of the deep pocket of government. But on the other hand, they may have labor costs which may be higher than private firms in their competitive environment. So there's a set of constraints which are different, and I will come back to this. And finally, there's the fact that they may feel invulnerable because they are part of the state apparatus and they may feel that they are above the laws. Each one of those five possibilities conceivably leads to competition problems or efficiency problems. Now, this is where the corporate governance rules come in, because the OECD has developed a set of governance rules that should apply to SOEs, which are mostly designed to make sure that they are as efficient as possible, given the constraints which they have. But some of them are really useful for the enforcement of competition law, as I will argue in a minute. So what are some of those rules which have been set by the Corporate Governance Committee? Well, the first one is that the first rule is that governments should ensure an effective regulatory framework for state-owned enterprises. For the part of activity which is not in the competition field, there should be a proper regulatory environment. The legal and regulatory framework for state-owned enterprises should ensure a level playing field in markets where state-owned enterprises and private sector companies compete in order to have market distortions. So that's first rule. Corporate governance clearly has an implications for a positive implication for competition. Second general rule, the state should establish a clear and consistent ownership policy, ensuring that the government of state-owned enterprises is carried out in a transparent and accountable manner. This is to try to solve some of the issues that I mentioned earlier about the fact that nobody really controls them, because very often there is a web of influence that apply to them. Another rule, a third rule, has to do with transparency and disclosure. State-owned enterprises, especially large ones, should be subject to an annual independent external audit according to international standards. Now, this is quite important because in a lot of competition cases, the competition authority has to assess whether, the pricing has been below the cost or something like this, and it's often extremely difficult for the competition authority to assess the costs, the real cost of state-owned enterprises. Because they have their own accounting rules, because they are not comparable to other firms, because they get resources at different prices. So having a benchmark, an international benchmark, can help the competition authority see more clearly what are the costs and possibly what are the allocation of costs between different activities, those that are under monopoly and those that are open to competition. And this is the next rule in the corporate governance of state-owned enterprises. Guidelines require that any costs related to the fulfillment of special obligation must be identified to the market and the general public. So it should be clear exactly what those costs are. Identifying those costs may require disclosing financial assistance received from the state. And all types of costs and benefits should be accounted for in a transparent manner. Again, this is extremely useful to enforce competition law, particularly when one comes to abuse of dominance by state-owned enterprises. Finally, a last corporate governance rule that I will mention has to do with the pricing principles that state-owned enterprises should apply. Wherever relevant, the guideline says pricing should be based on competitive market prices. In other cases, prices should be based on the principle of full cost recovery, costs as mentioned earlier, for each service, unless there is a clear rationale for less than full cost recovery. Now, this is quite important. A lot of state-owned enterprises run a deficit, loss. We don't know why. It may be anti-competitive. There may be a public interest, but all this has to be specified and be clearly accounted for. The pricing principle continues by saying that if supply of a commercial service in competition with private sector needs to be taken to ensure, care needs to be taken to ensure that the monopoly services is not subsidizing the commercial service. So the costing has to be accurate, it has to be transparent, and one has to make sure that there is no cross-subsidizations. So this is, I think, a very important background which is necessary for competition law possibly to apply to state-owned enterprises. And I submit to you that I think that competition authorities should, in their advocacy function, promote the adoption of those state-owned enterprise corporate governance guidelines, because it will make their life easier, it will make them better able to apply competition law. Now, let me finish on if we come to competition law, what are the principles that we should apply, or that we do apply? Well, the principle is the principle of neutrality of ownership. I mean, in principle, we're neutral. We don't make any difference. Commissioner Vestager reminded us this morning that there's also neutrality of nationality, but in the case that we're talking about, it's neutrality of ownership. Competition law should apply to any entity engaged in economic activity, regardless of its ownership or its legal form. Now, there are cases we know where competition law does not apply, either because there are formal exemptions, but by the way, the formal exemption should be accompanied by proportionate and appropriate regulation to minimize the risk of market distortion. That goes back to the corporate governance issues that I was mentioning earlier. Or sometimes there is an ad hoc defense that it can be provided by the state-owned enterprises, which includes its liability on a case-by-case basis. This is the case, for example, of the state action defense, which should be, when it exists, be very limited in its scope. Now, what are the possible anti-competitive practices of state-owned enterprises? They are, I would say, the classical one, but maybe more emphasis on possible abuses or exclusionary behavior, and Eleanor mentioned this. Predatory pricing, raising entry barriers and rivals costs, cross-subsidization, those are the issues that, from the competition law point of view, we may want to focus on. Now, there may also be cartels and mergers, but I was just pointing to the main abuses. What are the challenges, and I'll finish on this, of competition authorities when they want, or when they can and they want to apply competition law to state-owned enterprises? Three types of challenges. First, the institutional challenge. Are they independent enough to actually go after important state-owned enterprises? Are they going to be themselves under the influence of governments? Second, do they have the powers to do it? And in some cases, they lack the statutory power over the state-owned enterprises, particularly a municipal one, for example, or sometimes firms that are subject to the oversight by sectoral regulatory agencies, without those regulatory agencies necessarily being all that interested in competition law. Second type of challenge, what I call the substantive challenges. Information gathering. There we go back to the corporate rules that I was mentioning earlier. Where does one find the information on cost? How can one get into the accounting? How much transparency is there between with respect to the separation between various activities, etc. Second, the legal test relevance. How do I apply a predation standard to a firm that doesn't maximize profit? And we had a very good case in France, railways. The French railway company has huge deficit, which are covered by the state, so clearly it has an advantage there. But it is also restricted by law in the sense that its employees have a special status, which comes down to the fact that its variable costs are roughly 30% higher than the variable cost of the competitors. Well, in a case like this, and there was such a case, either you say the pricing of the railway company has been below the cost because it wanted to meet competition, in which case it was predation, or it is out of the market. Does the test, the legal test that we use, really make sense? Should we adapt the test to the particular situation? I've taken the example of predation. I could also take the case of merger rules. Do the threshold levels in terms of turnover make any sense for firms that maximize turnover rather than maximizing profits? Do corporate sanctions that the competition authorities may inflict make any sense on state-owned enterprises who are going to have their costs covered in any case by resources from the states? So there are a few challenges that we have to think about, and that requires competition authorities to think about how to apply the competition rules to state-owned enterprises. So my final point to sum it up is to say that there is convergence and complementarity between corporate governance and competition that competition authorities should get interested in those corporate governance issues because they will help them apply competition law more fully and more easily. They also have to think about how they could meaningfully apply their competition principles, which have been developed largely for profit maximizing firms to firms that don't necessarily maximize profits. Thank you very much.
And then I give the floor to Šarūnas Keserauskas. Please.
Thank you, and good morning, everyone. I'm very glad to be in Riga, in the city where my international lecturing career began and ended, quite sadly. Still, I have good memories, but I will not dwell into sentimentalities, and let's go straight to business of our discussion panel and the business of our work as competition authorities. It's good to remind ourselves as the competition agencies what the real problem of antitrust is, the challenge of antitrust. It is something that many companies want to achieve, but most of them fail. It is something that stands in the way of achieving maximizing consumer welfare. And that something is market power, significant market power. Also, the traditional thinking goes. And the traditional thinking leads the way to the traditional line of enforcement. Because of market power, we prohibit mergers that create market power. Because of market power, we prohibit abusive behavior of dominant firms. And because of market power, we object to creation of market power by way of collusion. All these prohibitions apply to what in antitrust jargon is called undertakings, entities that are engaged in economic activities. What is important that the concept of undertakings captures anybody that engages in economic activities. So the rules can apply to state-owned enterprises and to public bodies as well. So that is tradition, and I have no intention of breaking with the tradition. Market power is indeed the greatest challenge for our authorities, but having, as we should, being competition authorities, having inquisitive mind, I think we should dig deeper. What's the source of that market power? What's the prime cause? What's the prime mover? Who started all that? Well, quite often market power is created because some firms are simply better at selling products that people want to buy. That is great. And yet, too often, quite too often, market power originates from the state intervention. And we know that from our experience as the authorities and as just human beings. States can do this in many ways. And when I say a state, that term is very broad. It covers parliaments, governments, municipalities, and so on. So they can create or strengthen market power in many different ways, mostly by granting privileges to some at the expense of others, by raising entry barriers, and thus privileging the incumbent, shielding the incumbent from competition. Well, what are the ways of dealing with such a situation? According to the traditional approach, there are some tools. So we can enforce laws against state-owned enterprises, and Frédéric has talked about that. All that is good, though very complicated. And sometimes you can feel as an authority battling against with the consequences and not with the cause. At the European level, we have rules on state aid control. That is fine. And we always have the tool of advocacy. So advocacy, state aid control, and traditional antitrust rules. But there are downsides with these tools. As I mentioned, fighting the abusive behavior of SOEs is like fighting the consequences. If someone is given incentives to act in a certain way, it is very likely that someone will act in a certain way. And you can have repeated violations and repeated investigations. I know that we had at least several investigations against the Vilnius International Airport without much luck. Advocacy. Well, what if advocacy is simply not working? We like repeating that advocacy is not a replacement for enforcement. We usually say that in respect when we talk about enforcement against private firms, but the same should apply to the state. And when it comes to state aid, what if a particular measure does not constitute a state aid? What can we do? Well, I suggest that we can do more, and we should do more. We can go one step further and have rules that allow competition authorities to enforce competition laws against state bodies. Not only against firms, not only in situations when state bodies act as undertakings, but also when state bodies restrict competition, acting in their administrative capacity, in their public capacity. Well, this gets tricky and controversial because state bodies, they do not like being restricted. They don't even like, of course, and they don't like being restricted by other state body, the Independent Competition Authority. Because to be serious about enforcing against state bodies, not only should you have special rules designed to tackle this behavior, you also have to have an independent competition authority. Because you cannot enforce against your masters. Well, I suggest that the example of Lithuania is a good one to consider. Because we had enforcement against state bodies since 1992. The first steps of enforcement were rather timid. Then the law was restructured a bit in 1999, and that's when everything started to get going. So we have enforcement powers against public bodies, with the exception of the parliament, of course. We cannot go against the will of the people. Public bodies have two obligations. A positive one, in their activities, they must ensure freedom of fair competition. And secondly, a negative obligation, they must not discriminate. They must not give privileges to some businesses at the expense of others. So these are the rules, and we also have the competition authority that is independent to enforce these rules. I have already mentioned how important that is when you want to enforce against state bodies. Otherwise, you cannot talk about credible enforcement. And credible enforcement is something that we do have. Well, you may wonder what these figures means. It's the record of our enforcement track for the last 5 years. 24, it's the number of infringement decisions taken against state bodies acting in their administrative capacity. And 20 is the number of infringement decisions against private firms. Well, this shows at least two things. First of all, that competition restrictions by the state is a serious problem. And secondly, that we are serious about it. We are enforcing. Of course, that puts us and any authority engaged in that kind of action on a collision course with the state bodies. Sometimes you make government unhappy. Sometimes you make the parliament unhappy. But I think it's good for the government to have an independent agency that challenges its decisions. Because being open to criticism makes you stronger. So that's good for your reputation. That's good for investment climate. I want to give you 3 examples of enforcement, because always the question is, well, okay, you can have the rules, you can have the enforcer, but is that effective? I would say it's difficult, but it can be effective, and it has been effective in Lithuania, at least in some cases. Let's start with the case of 2006. That was an infringement decision against the police department. The situation that we had in Lithuania was that there was a special branch of police providing contractual security services to businesses and individuals in return for payment, of course, and in competition with private businesses. Well, the private businesses were very unhappy with the situation, and they filed a complaint. We did investigate the case, and what we found was that the police officers, obviously, being police officers, they had special rights. They could use blue lights on the car, they could carry guns, they could enter premises, they could detain people, and so on and so forth. All these things that were not available to private businesses. All these things that gave the police competitive advantage over private businesses. So we found an infringement. The case went on to the courts, several instances, and after 7 years of battles, years that involved both litigation and advocacy, what we managed to achieve was that in 2011, the parliament voted down the powers of the police to provide these commercial services. So from then on, the police can no longer provide commercial services to individuals and businesses. And I think that was worth it. It took 7 years. It took an infringement decision and long litigation and advocacy in the parliament, but finally, we achieved what was better for the market. The next example, it was a cartel case in 2011. Cartel, kind of a classic sort of cartel. Several producers of orthopedic devices get together and they agree on prices and on volumes. Nothing too interesting. There was one interesting detail though. The orchestrator of this cartel was the National Health Insurance Fund. The fund wanted to make its life a bit easier. Why go all the way in calculating volumes and prices and so on? So the fund invited companies to agree on everything and then submit the result to the fund so that the fund could compensate for these orthopedic devices. So we issued an infringement decision against the companies, finding them of a cartel, and also an infringement decision against the National Health Insurance Fund, finding it in breach of another provision in the law. Because in that particular case, the fund was in breach of the positive duty in its actions to ensure freedom of fair competition. Clearly, orchestrating a cartel is not freedom of fair competition. It's not something that the fund would be expected to do. And the last example, it's one of the most recent infringement decisions, so you don't see before and after division because it's still ongoing to a large extent. It's a case of Vilnius municipality taxes. Well, a taxi market is always problematic, and sometimes you may wonder why. It could be a perfect atomized market with many providers of services. And still, you go from one country to another and you see problems. Well, the problem in Lithuania, or to be precise, in the capital of Lithuania, Vilnius, was that some providers of services were not paying taxes. And using that excuse, the Vilnius city municipality entered the market, saying that we will provide better quality services and we will pay the taxes. the taxes. But that put the municipal taxi company in an interesting position because it received funding from the municipality, from the taxpayers. It had privileged access to to other resources. And also, the Vilnius city municipality acted as a regulator of the taxi market. So there was a clear conflict of interest as well. In 2014, we found an infringement against the Vilnius city municipality, and we ordered to stop the infringement. So now there are discussions going on how this should be done. The case is in courts, and we are very much looking forward to the end of this this case, and we are very hopeful that with the change of municipal government, with the coming of new mayor and new majority in Vilnius, the majority that preaches liberal values, that the municipality will withdraw from this market. So these are examples. And to finish off, I'll mention some of the issues that came up in these and other cases. The first issue in enforcing competition laws against public bodies is, and especially when it comes to municipalities, the first issue is that they're trying to defend their actions on what could be called the municipal autonomy argument. They say we are municipalities, we are autonomous, and the laws allow us to behave in a certain way. Our response is, well, the laws allow you to behave in a certain way, but you don't have to behave in a certain way, because there are other laws that prohibit you from restricting competition. That was a long dispute that we had with the municipalities, and we were very happy when the Constitutional Court, in 2 cases already this year, came with a decision saying that it's all fine, you can award contracts without running a competitive procedure, and that does not contradict the Constitution. But before doing so, you must first make sure that the market cannot provide these services. And that is something that municipalities rarely do. So that's the first issue, and we received the support of the Constitutional Court in this argument. The second issue is the effectiveness of sanctions. Now the only sanction that we have available is the mandatory order to stop the infringement. That is fine, but we cannot impose fines. Well, there is a question whether fining a municipality or any other body would be effective. Some say, and I remember myself saying that this would be just putting money from one pocket to another. But still, since municipalities are always short of money, if you take even a bit of money from them and put that money back to the state budget, I think that may start concentrating their minds. And next time, perhaps they will not enter the taxi market like they did in Vilnius. There are discussions going on about introducing fines to public bodies right now in Lithuania, but I'm not sure where they will lead. And the last, but probably the most important thing, is the independence guarantees of the competition authority that enforces these rules. And I'm not talking only about legal independence, I'm talking about de facto independence. And we all know the one weak spot that most competition authorities have is the funding. Most of the authorities that I know are funded from the state budget. And of course, the state budget is drafted by the government and adopted by the parliament. And it can always be manipulated. But there are examples in Europe, and I mean Greece, Italy, Portugal, where the authorities are funded in a way that is similar to the funding of the market regulators. So that is funding from the market by direct payments from the market players. That is something that we are pushing in Lithuania. We are trying to initiate a discussion, and we are expecting businesses to be favorable to this approach, if only because businesses should be interested in having an independent, legally and de facto independent competition authority. So that is it. My bottom line is we should get more serious about enforcing competition laws against state bodies. And I think not only in Lithuania, but also in some other countries, we have already started doing so. We just have to do more. Thank you.
So then I give the floor to Anita Vegter, please.
Good morning, everyone. Yes. I would like to thank the Latvian authority for inviting me to speak today. I will tell you about the ACM's experiences with the Dutch Act on competition, competitive neutrality between public enterprises and private-owned businesses. It is an excellent opportunity for us to exchange views on this topic. And this topic is rather special to me because in my role as a board member of the Netherlands Authority for Consumers and Markets, enforcement of this act falls under my portfolio. Well, the Dutch Act came into force in July 2012, but ACM has actually only been able to enforce this law, this act, since July 2014. And until then, a transitional regime was in place. So our practical experience with the enforcement of this act has been relatively short. And nevertheless, we are already assessing the effectiveness of the act because the act contains a sunset clause. And this means that the act will cease to exist from the 1st of July 2017 unless the legislator decides otherwise. I won't keep you in suspense for long. We don't want the act cancelled. However, secondly, we see that unfortunately the act helps achieve competitive neutrality only to a limited degree. Nevertheless, we think on the balance that the act delivers what it promises to deliver. And the question we need to answer is, what should it do more, or should it do more? Today I will tell you briefly about the background to the legislation, our assessment of its performance, and the questions that we feel still have to be answered. Of course, before we begin, I should say that competitive neutrality is much broader than controlling the government as entrepreneur. Competitive neutrality is also about the government as contractor. And that's an aspect that is covered by public procurement rules. And of course, the government as shareholder in major energy and telecommunications companies. That's an important aspect of competitive neutrality that is dealt with by state aid law, competition law, and sector-specific regulation. We are fully aware that this particular Dutch Act covers only a part of the full picture. Where the government acts as an entrepreneur, and just like private businesses offers products or services on the market, that's where this legislation applies. For example, think of a government organization that collects waste from businesses, or think of a municipality that commercially exploits a swimming pool. Such activities are not always harmful to citizens, but the risk of unfair competition is not that far away. Unfair competition occurs if a municipality gives its own waste management company certain benefits, such as cheaper loans, or if that municipality does not include in the prices the commercial exploitation costs of the pool. If that happens, it creates unequal competitive positions between the public companies and the private businesses that do have to include their costs in the prices and that rely on commercial banks for their loans. Unequal competitive positions may lead to businesses losing revenues, deciding not to enter markets, or at worst, even going bankrupt. There is no level playing field if governments use taxpayers' money to offer products or services at below cost price. Well, is this really a big problem? In theory, it can be. An ACM study has revealed that 83% of all local governments engage in commercial activities. Yet it took 15 years of public debate in the Netherlands before we got these new rules. And I know that some of you are still arguing with your own government for the introduction of these rules. The Dutch Act on competition neutrality between public enterprises and private-owned businesses did not come about without a fight. Legislation on this issue is sensitive because it impinges on the autonomy of governments to decide themselves what is beneficial for their citizens. It is therefore a very controversial topic, so it won't come as a surprise to you that the protracted political discussion about this law resulted in a compromise. And the law contains a major exception. That brings me to the substance of the Act. What do these new rules really entail? Well, first of all, the Act applies to all governments, which means all ministries, provinces, and municipalities, all public bodies, fall under this Act. The scope of this Act is thus very wide. The basic principle of this new law is that governments are free to decide themselves whether or not to enter the market. So there are no barriers to entry for governments that wish to offer products or services on a market. But if governments do choose to enter a market, they have to comply with the new rules. Two of the most important rules are governments must include in their prices the integral costs, which means all costs, of their products and services, and they are not allowed to give preferential treatment to their own government enterprises over their competitors, for example, by offering favorable conditions on loans. Well, I can hear you thinking, but don't the rules on state aid already prohibit this? Well, they do not, at least not in every situation. For example, if aid is less than 200,000 euro in 3 years, or if there is no interstate effect. If there is state aid, then the new rules do not apply, so double oversight is thus prevented. And that is a good thing. ACM enforces compliance with these rules. Governments must cooperate with ACM investigations. If ACM establishes a violation, the government in question must correct this, and in the worst case, ACM can impose an order subject to periodic penalty payments if a government fails to end a violation. The most important exception is that the Act does not apply to activities that are public interests. And governments are allowed to define certain activities as public interests. For example, municipalities are allowed to say it is undesirable to charge the citizens the integral costs of the local pool in order to ensure that such services remain accessible to a broad audience. So what is ACM's experience with these new rules? Do these new rules help realize a level playing field? A recent study revealed that many businesses consider unfair competition by governments a huge problem. In recent years, ACM received approximately 200 complaints. However, more than half of the complaints did not relate to commercial activities by governments. An often heard complaint is that businesses are of the opinion that the government carries out too many activities that could be easily left to the market. For example, think of the police that uses its own vehicles to tow cars from collision scenes. Or a municipality that has its offices cleaned or protected by its own employees. But these forms of insourcing fall outside the scope of the Dutch Act on Competitive Neutrality between public enterprises and private-owned businesses. Most complaints concerned municipalities that offer products or services relating to sport facilities, marina berths, real estate, training and educational programs, commercial waste, motorhome campsites, and parking garage. As you can hear, these are mostly relatively small commercial activities. But that does not take away the fact that the consequences of unfair competition for an individual business owner can be significant. ACM recently looked into the effect of the Dutch Act on Competitive Neutrality in 3 of these sectors. We focused specifically on sport facilities, car parks, and company waste disposal. The studies revealed that municipalities do comply with the law, but that this compliance has helped realize equal competitive positions only to a limited extent. One of the main reasons for this is that in many cases, governments decided that their activities are public interests, rendering the Dutch Act on Competitive Neutrality inapplicable. Furthermore, we have observed that in other sectors too, the public interest exception is used extensively. More than 90% of municipalities have decided that they carry out one or more public interest activities. What is striking is that private businesses hardly object to such public interest decisions. However, maybe companies are waking up because just recently the first lawsuit has been filed against a municipal public interest decision. However, that does not mean that the Dutch Act on Competitive Neutrality has not had any effect at all. First of all, the topic of competitive neutrality has been put back on the political agenda. Secondly, there are examples of local governments that have changed their practices, either voluntarily or after ACM had urged them to do so. And that is pure gain. So the first steps have been taken. The first ACM decisions enforcing the legislation are soon to be published. It is therefore a good thing that we have this law. Well, let me conclude. Earlier, I told you about the sunset clause. The Dutch Act on Competitive Neutrality is currently being evaluated by the Dutch Ministry of Economic Affairs. The results of the evaluation will certainly reignite the debate. Employers' organizations are already calling on lawmakers to revise the law. A decision must be made before the 1st of July 2017 whether or not the law should continue to exist in its current form. ACM's view is this law is good as far as it goes, but the scope is limited. Municipalities are complying with the legislation, and we have made it clear what is permitted by the law and what is not allowed. However, the effect of the legislation is limited. We will have some small decisions implementing the rules, but as I said, municipalities are largely compliant now. So if we want more changes, we will need other types of rules. And the question is whether a sharpening of the current rules would really solve the remaining problems as companies see them, These are more problems relating to insourcing and state aid issues. There are also problems when it comes to government as shareholder relating to perceptions and expectations of government's roles in defending national interests. These are not covered by this legislation. And that is why it is good that we are gathered here in Latvia to exchange our experiences and ideas about questions such as which rules are effective and which are not, and how can these rules be enforced efficiently. I know that this is also a topic that will receive renewed attention from the OECD in June. Well, thank you for your attention.
Yeah, thank you very much to our panelists, and I might use my privilege, whatever, to try to do what I found very interesting in 4 very interesting introductions. I find the main topic here being actually that the companies or the entities we are discussing today, they have a totally different objective than the ones with whom they compete, and I think most of the issues were raised here relate back to that. And I found three topics that I would like to hear more about. That is corporate governance. Looking into corporate governance, as Frédéric mentioned, is that a panacea that will help us addressing issues like we heard from Eleanor about you quoted the cement cartel in South Africa. Wouldn't have been possible without people in government or wherever. That's the first one. The second one is also this important issue raised on the Lithuanian case, the independence of the Competition Council. Are we really, with the current structure in most countries, able to regulate to some extent the hand that feeds us eventually at the end of the day? The third one, mentioned in several, we had it in Anita's in particular, the trade-off between the right of local governments, central governments to be independent, to act in the interest of the citizens on the one hand, but not to distort competition on the other hand, so to say. So those are the things I take with me so far in the discussion, and I will ask the first question and then I will open up the floor to all of you, and that is what really triggered me. That is corporate governance the new tool in the toolkit for the competition councils, and will they be able to do this? So that is a very open question, and I would like to hear the reaction from the panel members. Frédéric raised it, so guess where you might stand, but from the others, is corporate governance of the state-owned and municipality-owned or whatever owned public enterprises the thing that will help us solving it? So, you being unfortunate to be the one closest to me, so maybe you would like to open.
May I pass on that?
Okay, you pass on that one for a while. Anyone else being... Oh, Frédéric, you might then expand a bit on it.
Well, I argued precisely what you're suggesting, that this was an important help. And I think that the fact that there are guidelines on this at the international level, I mean at the OECD, is something that can help in the advocacy function at the national level. How far does it go? Does it solve all problems? No, but it does solve a number of problems that are either related to state aid control or related to how to enforce competition law enforcement. So I think that it's an absolute necessity. I take that the example that we've heard about the Netherlands is in fact congruent with this, because in the competitive neutrality part that you adopted, there are rules that are very close to this corporate governance idea. So clearly there can be a way forward.
Yep. Šarūnas, is this anything you would like to have in your toolkit?
Very, very quick comment, very short comment. I think corporate governance, of course, can solve problems to some extent, but as I was arguing in my presentation, it's mostly dealing with the consequences. And I think we should think about the causes. And the state should demonstrate more self-restraint. And of course, then you can apply the rules of corporate governance. And I know that our government is currently undergoing a reform of this corporate governance in the state-owned enterprises, mostly because of the OECD accession and other things.
Mm-hmm. Anita?
Well,
No.
it works? Yeah.
Yes.
Okay. Well, what you said, we adopted some of these rules, but what you earlier said about the costs and the transparency of costs, that is really what we considered that was really difficult. It is difficult to really see if they, how they calculate their costs. There are no rules for that, no accounting rules. They may use their own methods of accounting. So it takes a lot of encouragement to encourage them also to specify their costs, rather than allocate some high-level costs, what they usually do. So some rules on this, how to specify cost and be transparent to that, that would be a very good thing.
Mm-hmm.
So I think you might combine the idea of corporate governance with the idea of enforcement in the following sense. Compliance, I mean, corporate governance boards thinking about subjecting the company to liability for anti-competitive acts that are not necessary to carry out the public interest.
No, you're right.
Yeah, thank you. I know that we have one Italian speaker who would like to start the discussion from the audience. Please present who you are.
Thank you. I'm Roberto Chieppa, Secretary General of Italian Competition Authority. Some consideration about the situation of state-owned enterprise in Italy. Frédéric and Anita Vegter remember the importance of competitive neutrality, and I think that we all agree about the importance of applying competition rules with no difference regards to nationality or regard to the owner or the enterprise. But we know that some problems remain. In Italy, critical issues about public-owned enterprise concern especially the local level. At a national level, some critical issues remain with reference to railway or postal sector, but the situation of locally public-owned enterprise remains problematic. We have to underline that in Italy, and I think also in other countries, local public services sector can play a key role in fostering growth for its economic importance. In Italy, we have the presence of public-owned enterprise is really intrusive. There are more than 8,000 state-owned enterprises at local or regional level. They are active in all the sector, not only public services. The provision of these services is often monopolistic, although not all these markets are monopolies. The measure of local state-owned enterprise benefits awards without open tender, and in-house contract refer to services that are potentially profitable and could be open to the market. More than one-third of this company report losses. Finally, I think that political connection reduce the efficiency of this company. At a local level, we observe the resistance to the opening up of markets to competition, and also a tendency to reintroduce restrictions that had been removed at a national level. The reason is self-evident, in my opinion. The proximity of the administration or the regulator to the regulated facilitates a high regulatory capture. Against these risks, we have used all our powers, enforcement powers, also using the doctrine of Italian matrix case that Eleanor Fox remembered. Advocacy powers with some proposal to the government and to the parliament, but also with the possibility, we have the possibility of challenge in front of a court administrative acts that are in conflict with the competition rule, and we have used these possibilities in this sector against administrative acts that were in favor of local public enterprise and in contrast with competition rules. Our proposal, we have proposed that all regional and local authorities should not allow in-house exclusive services before making an economic analysis. And in this economic analysis, the first option should be competition in the market. When competition in the market is not possible, the second option, it should be competition for the market with public tender. And the last option, in-house services. We have also proposed a rationalization process of all the local owned company, and this proposal have been accepted in a proposal of reforms, draft law that now is in discussion in front of the Parliament. In conclusion, I think that we have to consider that politicians very often exalt state-owned enterprise as national champions, sometimes local champions, and other times European champions. But it could be a bad mistake, a great mistake, to create such champions sheltered, protected from competition. No question in respect of state-owned enterprise that are real and true national champions, but they have to achieve this status in a marketplace of effective competition, respecting market rules like all other companies, and not out of the markets. I think that this is the main issues that all the national competition authority have to use all this power in this direction. And as Šarūnas remembered, this is a good field to test the independence of the national competition authority from politics. And about independence, Šarūnas remembered the financing system of our authority. The Italian experience of a system of financing from the market and not from the state budget is a good experience. Thank you.
Thank you very much. Do we have some comments from the panel on the Italian experience? Yes, please.
I wanted to make a comment that your comment triggered. It may not be exactly what you would expect. I want to mention a word that has not been mentioned yet today, and that is China. And that is because China presents the problem you mentioned of a country, it could be a municipality, but mostly a country using state-owned enterprises as national champions and giving them many privileges and funding much of their activity and giving them very cheap loans and cheap rents so that they are in a position that is postured to outcompete any competitor unless the competitor is more efficient. Often the competitors are more efficient. This is a real problem in China. In fact, the Chinese have recognized that the fact that the state-owned enterprises have grown up with so much government support has made them so inefficient, and the Chinese government has recognized that China will be better off if they're much better subject to market disciplines. So I mention that I think it's a problem for the world to contend with the privileges of the state-owned enterprises in China. And I also see some forces in China that are trying to put them in a place that they're disciplined by competition. I agree with you that it's a very bad idea to think about giving lots of benefits to a state-owned company, thinking you're going to make it into a champion when actually you're probably making it inefficient. You're preventing the competition from growing up, and you're preventing all that innovation that would take place from the competition that grows up. And you're also creating unfair advantages.
Okay, thank you. Do we have more questions from the audience, please? Yes?
Hello, my name is Julia Yarneva. I'm a practicing attorney here in Latvia. I have the question about these effective and non-effective competitors. So, as Mr. Gianni mentioned, we have to look at state-owned companies a little bit from a different perspective. They have special responsibility. Talking about Latvia, for example, one of the responsibilities would be to play fair, to pay the taxes, to actually have official employees, and so on and so on. This may sound maybe a bit outdated for the old European countries, but here in Latvia there are some sectors that face the problem of private competitors not playing fair. And as a result, a dominant state-owned enterprise is faced with the obligation to put all the costs, as you mentioned, into the price, at least the variable costs, and they lose the competition because their competitors do not play fair. So when we are faced with the case with the Competition Council, maybe you have any experience of the cooperation between the competition authorities and the tax authorities, because Competition Council does not have the power to state directly that there is, for example, no violation because of the non-payment of the tax by the private parties. You see that there is a clash of competences. Maybe there are any other examples from the Lithuanian competition authority. How do you deal with the private parties actually harming in an ineffective, non-competitive manner is the business of the dominant state-owned enterprises, and as a result, do you find violation or not? How do we play with that?
Thank you. Frédéric?
Yeah, I'm not sure.
The question was essentially, as I got it, when the state-owned enterprises play according to the rule book, they pay the taxes, we have the opposite problem that they might have a disadvantage vis-à-vis the private ones. And also, the second question, part of that question was whether the Competition Council should be able to cooperate with the tax or revenue service to look into unfair competition in terms of paying or not paying taxes.
On the first point, what I mentioned, but maybe too briefly, is that there are many cases where, when you look at state-owned enterprises, there are both advantages and disadvantages, and it's quite important to actually accurately make, I would say, the sum of those advantages and clearly on the financing, clearly the fact that you cannot go bankrupt, clearly the fact that you cannot be taken over. This is equivalent to a subsidy. Now, on the other side, and this is, of course, the example that I was giving on the railway, there may be all kinds of limitations on what state-owned enterprises can or do, which would not apply in the private sector. So I'm not saying that this balance is easy, but it's clear that it's very hard, and it is probably not a good idea to make decisions which are based on some of the cost or some of the benefits, forgetting the other part of the balance. That requires, in fact, a matrix to really analyze all the pluses and minuses to try to get back to the accounting of all this. I mean, there's an issue of evaluation of the resources, but there's also an issue of taking into account all the aspects of. To say that we are very far along this, I'm not sure. As I said, I mean, this is an issue in France because the courts basically, I mean, in the railway case I was talking about, because the National Railway Company, which is losing tons of money, and you wonder really why we have, this is on freight transportation, either has the choice of if one applies the competition rules, and if one only looks at the fact that it is subsidized, has the choice of either leaving the market or in fact being found in violation of competition law for predation. But there's no other choice. And the courts have had a hard time accepting that this was a sensible way to apply competition law. So they have overruled the competition authority. Well, we don't have the final word because it is now in front of the Supreme Court. But there was a question there. There were several questions. One of them is, did the accounting of all the plus and the minuses, was it well done? And if it leads to a situation where either the firm leaves the market or is in violation of competition law, if it tries to compete with private firms, does that make sense? So we do have several layers of problems. One of them is on the accounting, as you mentioned. The other one is then on how do we adapt the rule, if it should be adapted, or maybe it shouldn't be adapted, but what are the consequences of applying a rule which has been designed for profit-maximizing firms when you apply it to firms that clearly do not maximize. And I'm saying this because the French railway on freight was losing tons of money when it was a monopoly. So it's clear that there's something going on which has nothing to do with the profit motive in this case.
Yeah, thank you. Yeah, Eleanor.
Yeah, I wanted to add to the question of the balancing, because you have many state-owned enterprises or enterprises with exclusive privileges, and they may say, I needed to do this act, which we know is anti-competitive, because otherwise I'd be losing money and I won't be able to do my universal service. The thing I wanted to add is this, and I want to go back to the Slovenska Posta case. The adjacent market was a competitive market. Competition would do well there. Is it a good idea? Supposing the Post was able to prove that its costs were such and its obligations were so great that it needed extra money, is it a good idea to say, oh yes, you can have that monopoly in the adjacent, otherwise competitive market because it will pay for you to sustain your universal service? So I want to suggest that's a bad idea. That for the universal service, they should be directly subsidized. And I think that the European Union has it right in at least putting the burden on this company to show, this sort of undercuts part of my absolutist principle, but at least the burden on the company to show that it could not survive without the extra revenues. I think that should probably not be the test, though, because competitive markets ought to be able to stay competitive, and then it pushes you back to the role of the government in paying for the universal service that doesn't pay for itself.
Yeah, please.
Just on the second part of the question, if I understood well, the question was whether one could use unfair competition laws when there is clearly a disequilibrium between one firm which has a special tax status and the others who don't have the same tax status. It seems to me that it would be quite difficult because really what the firm is doing is using the piece of legislation that says that it doesn't to pay taxes. So it's hard to say that the unfairness comes from the firm's behavior. So I mean, it's more, trying to advocate competitive neutrality and the fact that there shouldn't be different tax system for competitors who are in competition. But using the unfair competition law, I mean, it depends on the legal system, but I think in many countries it would be difficult because it's not an unfairness of the firm itself, the state-owned enterprise, it's an unfairness of the system in which it operates.
Šarūnas?
And just very briefly, since I don't know if is it working? Yeah. Very briefly, since Lithuania was mentioned, we heard similar arguments in the Vilnius municipal taxes case that, look, we have to enter this market because others are not playing by the rules, they're not paying taxes, and we will enter the market and we will pay taxes. For me, that's a pretty bad justification for entry because you're using taxpayers' money, municipal money, to enter the market just in order to pay taxes. Well, that's, and not to mention that this particular company has never been profitable. So I wonder whether they wasted more money than they paid in taxes, but that's a different story.
Anita, do you have any comment? Do we have one more question from the audience? Yes, please.
I would like to briefly touch upon the issue raised by Mr. Keserauskas, that is about the fining policy. And the question is really very brief. Should really state-owned enterprises benefit from lower fines for comparable competition law infringements than private entities? And isn't that what you might call price discrimination that might lead to market distortions by itself?
Well, the answer, I think, is pretty simple. No, they should not. And under our system, there is no way they could benefit.
Okay, I see that I have 30 seconds here, and we are very tight now, 29 seconds to wrap this all up. And I would say, yeah, we have a long way to go until we have, if we ever will get a level playing field between the private and publicly owned companies. And as highlighted, we might see if we meet here at the next, I guess Latvia might have the European presidency in something like 14 years. And if we meet again in 2029 or something, I hope we will have got a bit further, and I guess we might see that corporate governance then being one of the things that are clearly integrated into the policy of competition. So with that very short summary, I would like you to join me in a warm hand to our panelists. And before we do that, I would also like, on behalf of the organizers, to invite you for lunch, which is out there, and lunch starts more or less now, and we come back here 20 minutes past 1 to discuss cartels and related issues. So thank you very much, and a special thank you to our panelists. So,